The Second Circuit heard oral argument for Zarda versus Altitude Express. The panel will decide if sexual orientation discrimination is protected under the Civil Rights Act. In 2010, Donald Zarda, a skydiver instructor with Altitude Express, filed suit alleging he was fired after he told a client he was gay. Mr. Zarda passed away in 2014. His estate is continuing with the suit. This is an hour and 45 minutes.
Good afternoon. Each side has been assigned 30 minutes, divided 10 minutes per person, and that time may be exceeded depending on how things go during the argument. We'll hear from Mr. Antolino.
Good afternoon, Your Honor, and all of Your Honors. I forgot to introduce Steve Bergstein, my co-counsel who worked with me on this case. We're proud to represent Melissa Zarda and Bill Moore, the executors of the Zarda estate, and we ask the court to construe and unite Title VII with life as we live it and under the plain language and its interpretations. We ask that you find that sexual orientation discrimination is sex discrimination under Title VII. Don Zarda was a male. He was known as gay, though he was not traditionally effeminate, but he was a great skydiver. When a customer complained that he identified himself as gay, he was fired. And for that revelation, it was a violation of the statute because his sex, a male who was attracted to other men, was a motivating factor in the adverse action. And in this case, he identified as gay only because he was accused of being straight. And he was proud of being gay, and in the male workplace of the skydiving community, jokes were often made that loosened the tension of the experience, and jokes were often sexual.
Is his claim that, is he alleging that he was fired because he was gay or because he disclosed that he was gay? What is the precise nature of his?
It's all part of the puzzle. He was known to be gay, but because he came out as gay to a customer, he was discriminated against because of that. And that identification was a sex discrimination because it dovetailed with his being male and being attracted to other men. The simplest interpretation of the statute, I believe, is in Judge Flaum's concurrence in the Hively case, although I didn't state it in my brief, or didn't recite it in my brief. Judge Flaum's concurrence is really quite to the text and holds that if Title VII requires that a plaintiff need only identify that sex was a motivating factor, and that sexual orientation cannot be extricated from sex. Therefore, the two are one in the same. There are also two other evidentiary theories, I don't know what you want to call them, routes to interpreting sexual orientation discrimination as sex discrimination. And the first and most obvious one would be associational discrimination, whereby an employer, if he makes or takes an adverse action against an employee because of the protected class with whom the employee associates, has been found to have violated Title VII. Judge Eggington held this precisely In Boutillier, the opposition alleges that...
Are you alleging associational discrimination here, and what are the facts that support that claim?
Well, I think that in and of itself, a man who identifies as gay associates with other men and is seen to associate with other men. In addition, in this case, we don't want to exclude single people, but in addition, in this case, Mr. Zarda also told the female skydiver, whom he sensed was uncomfortable because of the sexual joke, that I'm gay and I have the ex-husband to prove it. And his ex-husband was not his husband, it was just a phrase he used, who is the executor of his estate and is in court today. And so that was the association. That could be in a specific association, but it's also a general association. The third theory or evidentiary route to reaching a violation of Title VII would be sex stereotypes.
Isn't that the only one, at least in what I have here, is the only one you actually pleaded with sex stereotypes?
I believe you're right.
How was that before us then? It was, the summary judgment was granted on that, and you didn't appeal it, and the panel opinion said it's not before them. How is stereotyping still before us?
Oh, I don't understand the panel opinion as saying stereotyping is, well, the panel opinion said that
rule is unavailable to Zarda since, as explained, the district court found that Zarda failed to establish the requisite proximity between his termination and his failure to conform to gender stereotypes, and you didn't challenge that on appeal.
I understand your point now, and what that takes into account is the traditional effeminacy argument that a male may make. I do not conform to sexual stereotypes in that I am effeminate in certain ways, but we did argue that after Baldwin came down and we moved to reopen Title VII, that sexual orientation is the ultimate, or gay orientation in this case, is the ultimate sex stereotype. So while there were a few little snippets of pink toenails and whatnot, the argument is the ultimate sex stereotype, as opposed to the bean counting approach of, well, he wore womanly clothes and he spoke and his voice sounded gay and whatnot. It is a broader sex stereotype.
So are you saying that gay is sex stereotyping?
Gay orientation
is sex stereotyping? Anything that people can imagine one way or another is sex stereotyping?
It is the ultimate sex stereotype in that men are expected to prefer women affectionately and sexually, and women are supposed to enjoy that protection, that affection.
To that extent, is it a stereotype that's being applied to both sexes? I ask this because the concern we have is whether we have a discrimination that fits within sex discrimination or something different that, while discriminatory, may not differentiate between men and women. So is the sex stereotyping you're talking about applicable equally to men and women homosexuals?
That is the question that comes up again and again. And the answer is that it does apply equally, but both men and women are being discriminated against.
But is that what sex discrimination under Title VII is meant to prohibit?
Well, that's a very broad question, and I could go, I mean, I could write a whole article for you about that. The different ways that courts have interpreted sex discrimination under Title VII. A comparative example would be, what if an employer disfavored or discriminated against Christians who dated Christians? Are they being treated the same? Or are they being discriminated against because they are Christians? The same rationale, although it is not exactly precisely on point, was made in Loving against Virginia, wherein courts had held for many years that the races were treated equally, but in fact, each race is being treated, being discriminated against. And in our belief, the discrimination is against Don Zarda because he was a male, because it was a motivating factor in his termination. Had he been a woman, this wouldn't have happened.
Well, let me ask you about that. If the client had been assigned to a woman skydiver who identified herself as gay, it seems to me from the facts we have before us that the client probably would have complained just as much, and the female instructor would have been fired too. Am I missing something?
That's hard to say. I cannot speculate as to whether it was actually the client's boyfriend who complained. But the reason it came up in this case was that Don was accused of having some sexual dalliance with this woman, and he took himself out of the equation by announcing he was gay. If he had been a woman, I don't think that in a heteronormative society, someone would have made a joke like that, and the teleology of events would not have played out as they had.
You'll have 3 minutes.
Thank you very much.
Mr. Horowitz. Question before the court is a pure question of law, whether Title VII prohibits discrimination on the basis of sexual orientation.
Yes, sir.
How do you respond to the criticism of the of the comparator hypotheticals, in particular the criticism that comparators change both the sex and sexual orientation of the hypothetical employee?
Well, Your Honor, excuse me. The goal in terms of the analysis is to determine the effect of the individual's sex on the way they're treated. And so to do that, the Manhart decision tells us that what we do is to look at the individual. If you change the sex of the individual and the outcome would be different, that's discrimination because of sex.
So one of the criticisms leveled by the department and by Mr. Mortara of this comparator test is they point out that a woman who's fired for chronically using the men's restroom or locker room would not have been fired had she been a man. But it's pretty clear that an employer could fire her without violating Title VII. What's your response to that?
Well, Your Honor, the bathroom issue, while it's often relevant to cases of transgender discrimination, it's never been relevant to, or at least not as far as I know, not relevant to a case of sexual orientation discrimination. And in fact, to bring it up, concedes that sex is an element, that sexual orientation discrimination involves an element of sex. Sorry, Your Honor?
Isn't that criticism designed to show a weakness in the comparator test? So the comparator test is not a perfect test. Would you agree with that?
I wouldn't say, in the focus of Manhart, I think it's a very useful test where it's not that you necessarily need to find an identical comparator who works at the location. What you're doing is comparing the individual with the hypothetical situation in which it's the same individual but a different sex. Is the outcome different? And that's exactly what Loving tells us to do in the race context. And here it applies equally in the sex context. But if I may get to your point about the bathrooms, by conceding that sex is relevant to the question of sexual orientation, then bringing up the bathrooms, that's essentially saying, let's look at the terms and conditions. But which bathroom one uses is very different from one's choice of a partner. And the choice of a partner has been held by the Supreme Court numerous times to be fundamental. So it's a very different thing.
When you say you change the sex, that's the Manford test. It seems to me there's still a little ambiguity as to how we do that. To use this case as the example, is it that we change it and say a instructor says, I'm gay? Or I think what you're urging us to do is say a woman instructor says, I'm attracted to men. And the comparison could be either one, and we might get different answers. What guidance would you give us?
Well, I believe what your question gets at is sort of the focus of the analysis in terms of the individual. And here, case after case has said that you focus on the individual's experience. And so
here is we have a male instructor who told a female client, I'm gay. Mm-hmm. So why is the comparison not a female instructor saying to the woman client, I'm gay?
Well, in the case of a female instructor saying the same thing under Price Waterhouse, that would be if her sexuality was determined to be the reason that she was fired, that would, both Mr. Zarda's case and this hypothetical case, in both cases, the person would be fired for not comporting with the employer's, or in this case, the customer's view of proper gender roles.
I understand that argument, but that then gets us to whether that's a matter of sexual orientation that's different from sex discrimination. I mean, it somehow seems curious to say that in that circumstance, both a man and a woman would be fired, and it's sex discrimination. So how do we reach that conclusion?
Well, in that situation, both a man and a woman would be fired because they are not comporting with this view of proper gender roles. Which
I suggested to co-counsel is now being applied equally to both men and women. There is a presumption, a stereotype, a bias, whatever we want to call it, that people should be attracted to people of their same sex. And it's applying both to men and women. And I'm having trouble understanding how that's discrimination that differentiates between men and women as opposed to a different kind of discrimination that we might well wish to prohibit, but that's not sex discrimination.
I believe it's still sex discrimination because what you're doing is you're holding both individuals in that case, both the man and the woman who are fired for their sexuality, you're holding them to the same standard of gendered behavior that Price Waterhouse says is not appropriate.
Well, to be clear then, Mr. Horowitz, in your response to Judge Radji's question, it sounds like it isn't really the Manhart test. You've now switched the ground to another argument, which is the argument from sex stereotyping, because I think what her questions were going to was, why shouldn't we, if the test is just, if a woman said the same thing, it would be different? Why isn't that the right way of applying that test?
Well, and I apologize if I misunderstood your Honor's point. That's exactly right. I mean, with these three ways of looking at it, these three paths that we've proposed, some may fit more comfortably in a given situation than another, but the underlying, the ultimate underlying idea with all three is that sexual orientation is within discrimination because of sex, and that, in fact, that's based on how the law has been interpreted, and to try to cut them out, to cut sexual orientation out of the protections, in parts into Title VII jurisprudence, an exclusion that's just not there, that's just not based on the statute. But you're exactly right that in that case, it is perhaps easier to look at the Price Waterhouse analysis of sexual stereotyping rather than looking at the individual, although I believe it still works in that context because you're comparing the individual with, I have hypothetical same individual, same conduct, but different sex.
You're using sex and gender interchangeably? Is that problematic?
Much like with the Hively decision and much as the Supreme Court has done, for the purposes of this issue, I am using them interchangeably as the courts have done. I don't believe that's a problem.
Well, the statute doesn't refer to gender.
That's true. The statute doesn't, but Price Waterhouse does use gender and sex interchangeably. And so that's how the courts have approached that issue.
Going back to the but-for test for a moment, in Manhart, are you saying that that test, I mean, the language of the statute is discrimination because of an individual's sex. Are you saying that the but-for test is the best interpretation of that language? Or are you saying something specific about sexual orientation cases?
No, Your Honor, I'm saying the but-for test is the most appropriate in that case.
I mean, there are additional cases beyond the example of restrooms that don't seem to follow within other, like Jesperson in the Ninth Circuit, or the recent case of Bauer in the Fourth Circuit. In Jesperson, the sexes are treated differently, but there's a determination that that's not an adequate basis for finding a violation of Title VII because they're not similarly situated.
That's correct, Your Honor. And in terms of the terms and conditions applied to each sex, this court held in the Tavora v. Mercantile Exchange case that in that case the idea of a Manhart test didn't apply to a hair length restriction, and the court held that in that case where it was something relatively trivial at issue, then it didn't need to be applied. But with respect to—
Does that draw into question whether the but-for test can be the meaning of Title VII, the interpretation of the language discrimination because of an individual's sex, or am I misunderstanding?
Well, Your Honor, the but-for test in that case is one useful path to look at. It might not cover every fact pattern. And in the Tavora case, for example, there was that hair length restriction, and the court held because it was relatively trivial, the difference in treatment didn't go to something fundamental about terms and conditions, but one could imagine a case in which it really would, in which the standards that one sex is held to are very different from the standards another sex is held to.
Your adversaries say that the Civil Rights Act amendments of 1991 should be understood as ratifying the proposition that sexual orientation discrimination is not prohibited under Title VII.
Yes, Your Honor, and that's incorrect for several reasons. First, as the Pension Benefit Guarantee Corp case holds, legislative inaction is a very poor means of determining congressional intent. Particularly in this case, it's a poor grounds for a number of reasons, including that you don't know what the grounds for amending the statute or not amending the statute might be. It might be that they think it's already included. It might be that they think it doesn't go far enough. There might be something else about the bill.
Isn't there a difference between legislative inaction and legislative reenactment of a statute in effect with the whole set of amendments in the face of a broad consensus of judicial opinion as to what the statute means?
Well, Your Honor, I would disagree with the broad consensus. At the time that 1991, when Congress was taking up the issue of amending the Civil Rights Act, there were only a few circuit court cases. None had looked into the issue with any sort of rigor, and the Congress generally amends statutes in response to Supreme Court holdings, not those of circuit courts. And in fact, in this case, one could just as easily argue that because Price Waterhouse was one of the driving cases that led to the amendment, and the Price Waterhouse analysis focused on sexual stereotyping, but Congress didn't cut sexual orientation out of the protections of the statute when they could have. And they'd done that in 1990 with respect to the ADA. They'd done that in 1973 with respect to the Rehabilitation Act test.
When you say that Congress generally amends in response to Supreme Court decisions, are you aware of any congressional action by way of amendment or reenactment that's in response to a circuit court decision?
I'm not, Your Honor. I'm not.
Do you think that the legislative intent in 1964 is relevant?
No, Your Honor, I don't.
Why is that?
Well, in the on-call decision, Justice Scalia said that it's the words of the statute rather than the concerns of the legislators that drives the interpretation of the statute.
There have been legislative acts in response to circuit court decisions, but they've been explicit in indicating their disagreement with those decisions and changing the law in response to those decisions. I take it that in this case, your argument is that There's no mention of any of the relevant circuit court decisions, and to the extent that Court of Appeals decisions are mentioned, it's about, or Supreme Court decisions are mentioned, that are about different issues, and that the purpose of the 91 amendments was to expand the scope of protections rather than to contract them. In fact, that's the language, isn't it?
That's exactly right, Your Honor, yes.
Could you take a minute to address the change in position of the EEOC over the course of the years?
Certainly, Your Honor. We took a fresh look at the issue, much as the Hively Court did, much as Chief Judge Katzmann's concurrence in the Christensen case did. We took a new look at that in light, in part, of the Supreme Court's guidance over the past 15 years, now 17 years, and in part based on our conversation with stakeholders, both employers and employees. And when we sort of swept away the preconceptions and just looked at the legal argument, we ultimately concluded that based on the way courts have interpreted Title VII, sexual orientation discrimination is and cannot be separated from...
You agree that these arguments were available well before Baldwin?
Yes, Your Honor, I do agree that they were available, but I think the Seventh Circuit and perhaps the Circuit and the EEOC just perhaps did not give those arguments.
They were available to the EEOC. So the EEOC has been aware of these arguments for years. Is that correct?
We've been aware of these arguments the same way the courts have, Your Honor. That's true, but we...
And as to the deference that we owe your position now as opposed to the deference we owed your position then, what is the import of the change, and what would you say about what deference we do owe to your interpretation of the statute?
Well, Your Honor, we are under Skidmore. We're entitled to deference based on the persuasive value of our arguments. But in assessing the persuasive value, it's important to keep in mind the EEOC's position in the broader administrative framework.
How is that different from deferring to your argument today? It's just it's a question of the strength of the argument, not the fact that you're the EEOC.
Well, it's certainly right. It's a reflection of the strength of the argument, but it's also an argument that has been informed by our experience as the agency that's tasked by Congress with the interpretation, the administration, and the enforcement of Title VII. And in fact, when we went to revisit our approach to the issue, we solicited input from stakeholders, including both employers and employees, and that helped us come to our...
You talk to the DOJ?
I'm not...
Soliciting opinions?
I'm not aware.
We love to hear from the federal government, but it's a little awkward for us to have the federal government on both sides of this case.
Indeed, Your Honor.
Your point is, well, on the deference point, what you're acknowledging is that your argument is not entitled to Chevron deference, which would be the highest form of deference.
Correct.
But is simply entitled to deference to the extent that the argument is persuasive, and that takes into account, under doctrines of administrative law, changing conceptions that administrative agencies may have over time as to particular legal questions.
That's exactly right.
Does the EEOC have a position about Judge Flaum's concurrence in the Hively case? Is it something that the EEOC could agree with or agrees with?
Well, certainly Judge Flaum's approach, where he looks at whether somebody is being discriminated against because of sex, and he looks at it in terms of they are a man who has a relationship with another man, and so if that is what drives the employer's animus, then that's discrimination necessarily because of sex. And that is fully in line with our position.
May I ask you a question about your view on sex stereotyping? In Price Waterhouse, Justice Brennan's plurality opinion suggests that not all sex stereotyping will support a Title VII claim, and I'm wondering if you construe that to mean that the sex stereotyping that is evident in any particular case has to bespeak or support a finding of intent to discriminate between men and women.
I think it has to bespeak a finding that it's an intent to sort of hold employees to a standard of behavior in conformance with the employer's views of what behavior is proper for men and proper for women.
Well, that would suggest that all sex stereotyping is prohibited. And the particular example that Justice Brennan gives is one where he thinks women are put into a catch-22. Be too aggressive and you're not considered feminine enough. Don't be aggressive and you won't succeed the way your male counterparts do. So you're going to be fired if you're too aggressive and fired if you're not aggressive. That's the catch-22 that he says Title VII takes women out of. And then it's the very next paragraph that suggests that not all sex stereotyping will present a Title VII violation. So I'm trying to figure out where you think sex stereotyping plays in all of this. I mean, many of the arguments that have been presented have suggested to us that sex stereotyping is prohibited sex discrimination. And I'm having a little trouble with that in light of what is said in that part of Price Waterhouse.
Well, Your Honor, perhaps it goes back to the Tavora decision where if the sex stereotype at issue is hair length, for example, this court said that's a relatively trivial distinction, and so based on that, the court was not prepared to find that there was discrimination because of sex. But in terms of where sexual orientation is involved, that's far from trivial. That's a fundamental right. And so even if there is an exception at the level of hair length, that would not apply.
Well, taking it here...
why it's different when something is trivial and when something is important, of course, as a matter of public policy. But where do you get a rule out of the statute that says trivial sex discriminations aren't discrimination on the basis of sex, or trivial sex stereotyping issues are not discrimination on the basis of sex, but big-time stereotyping is?
Well, Your Honor, that's the way this court has interpreted the statute and interpreted Manhart.
So there's a difference between, or a distinction between trivial and fundamental discrimination.
Yes.
Title VII.
And a sex stereotyping that applies to both men and women, as in people should be attracted to persons of the same sex. How does that now play in?
Well, the sex stereotyping, that says that if you are a man attracted to men or a woman attracted to women, either way, you don't meet the stereotype that the employer has for how your gender should behave. And so in that case, you're being put to a question. Do I keep my job, or do I have my choice of partner?
But is it putting a disadvantage on one sex, either men or women, or is it putting a disadvantage on homosexuals, and that's now the distinction? It's not men and women, it's homosexuals versus heterosexuals.
Your Honor, it's putting a distinction on an individual basis because of sex. And when an individual is discriminated against because of sex, regardless of other people that might fit in that group, looking at the individual, that is discrimination.
Is it sex discrimination, in your view, if an employer fires an employee for cohabiting out of wedlock?
Yes, Your Honor, I think that, well...
That would make this a very broad doctrine, wouldn't it?
If it were for cohabiting out of wedlock, that might, but sex was not a factor of the cohabitation. That would be applied to men and women cohabiting.
It would apply to men and women. It would apply to men and women who are homosexual or heterosexual. I'm just asking a really broad question.
I see.
Whether there are any limits to the doctrine that you are proposing.
Well, in that case, I don't know if it fits within one of the paths of analysis that we've suggested in our briefing.
It may not, but that's sort of why I'm asking the question.
Right. So in that case, I think if you...
It would be based on sex, would it not?
Would not be based on the individual's sex. No, Your Honor, I don't believe so. If it's cohabiting, I mean, that might raise other concerns, but it wouldn't be, in that case, I don't believe it would be a distinction.
Well, it would if it were a man and a man or a woman and a woman.
I mean, if that were the grounds for the distinction, but if a man would be terminated for cohabiting with a woman, but a woman would also, or a man, and a woman would be then in that case, the man-heart test, it doesn't seem like that would result in, yeah, I don't think either under Man-Hart or the Price-Waterhouse analysis.
Thank you.
Thank you, Your Honors.
Mr. Nevins?
Thank you. May it please the Court, my name is Greg Nevins on behalf of invited amicus lambda legal. Title VII's ban on sex discrimination because of sex necessarily includes a bar on discrimination because of sexual orientation, because to discriminate based on sexual orientation is differential treatment based on whether an employee is male or female. If a hypothetical female employee named Denise Zarda would be hired or retained despite romantic involvement with the man, but Donald Zarda was not, then we have sex discrimination. And in response to the judge's immediately previous question, I think actually one of the ways in which the courts have gotten a little bit off the rails on this is based on the Dissentio opinion. The court says sex does not mean the sex you have. Sex means the sex that you are. So in other words, if a employer were to condemn all extramarital affairs or all instances of cohabitation equally, no matter who was involved, that would be okay under Title VII, because Title VII does not mean sex you have. But to affix a scarlet A and a pink slip on the woman who has an affair, but not the man who has an affair, that's where you run into the problem under Title VII.
This does have religious freedom ramifications.
It probably does, Your Honor, and I believe that Altitude Express has not invoked any such things, and that will be a weighty consideration. But I think one of the pearls of wisdom that the Christensen concurrence left us with is that when you don't have all the best arguments and don't have all the full arguments in front of you, it may not be the best moment for you to opine on broad statements of what is covered and what is not covered. So I believe that, Your Honor, I feel confident that there will come another day in which this court will be called upon to address that question, but that day I do not believe is before the court today.
Could you address more specific what you've heard about the comparator approach and how we should think about the comparator approach?
Well, of course, the court has the benefit of our take on it, which is that Your Honor's take was exactly correct in the Christensen concurrence. That if you
I asked the question.
And I'll go back to the analogy. We tried to come up with a non-alcoholic analogy, but I do believe that if you have, vodka and you change grapefruit to juice or orange juice to grapefruit juice, you've only changed one thing. And they're trying to play a parlor trick on this court by saying you're changing two things. By saying that you change a screwdriver to a Greyhound. But another, what would happen?
How do you change it in this case? How
In
do
the-
you change it in this case?
Well, first, and
Put
you're
a woman in scenario. Tell me how you do it.
Absolutely, Your Honor. And I appreciated your questions earlier and I think we have to look at what the significance of what it means to say I am gay, because let's be honest. You're saying I'm a man attracted to men, or in the case of a woman, I'm a woman attracted to women. We cannot divorce that reality from what's going on. So therefore, if that would not be problematic for a woman to say I'm attracted to men, but it is problematic for a man to say it.
That's not what he said.
I understand that, Your Honor, but words have, in order for just to say I'm gay, obviously 100 years ago, that meant that you were a very happy person. But today, the significance
is that the likelihood that a woman would have said it in this case may be suspect, because the reason that the instructor said it here was to put aside her concerns that she would be sexually molested in the course of this close contact. But now we're applying a test and you're saying, don't change anything except the sex of the plaintiff. Okay, but you don't want to do that. You want to interpret what the plaintiff said. And I'm not sure why that's not playing with it as much as what some of the things that your adversaries have urged us to do is. Why do we do anything more than say, okay, if a woman had told this client she was gay, she would have what? I mean, I think the male companion might have been even more upset, and the criticism would have been even greater. What am I missing?
Well, Your Honor, my very capable friend, Mr. Antolino and Mr. Bernstein, do have to go back with any favorable ruling this court would issue and prove that sex was a motivating factor. So, in other words, if Altitude Express demonstrated that any statement by any instructor that involved their sexual interest was absolutely grounds for termination, that's a different case. But here, what the allegation is that what he said was, I'm a man attracted to men, and so that was the problem. And they have to show that would not have been the case if a woman had said something like that. And they're very capable of doing that on appeal. But I believe that the reason why this court is convened in banc is to just answer the question: if he can make that showing, has he stated a Title VII claim?
We'll take it to a next step in level of generality. Let's say you have the situation which an employer would equally fire male and female homosexuals.
Well,
that's sex discrimination under Title VII?
And if I could, if an employer said, I've seen the statistics about the failure of interfaith marriages, and I see that...
The hypothetical I gave you, if an employer would fire a male homosexual or a female homosexual.
What I'm saying is discrimination against someone in a same-sex relationship is the same as discrimination against someone in an interfaith relationship, is the same as discrimination against someone in an interracial relationship. And they all are equal.
The trouble with that is that the factor, religion, race, is itself one that is deemed invidious. Here, that's not quite what's going on.
And I would respectfully disagree that.
Tell me why.
Yeah, because if I say all I'm saying is no interfaith relationships, and as my EEOC colleague said earlier, Title VII applies to the individual. So in order to actually enforce that, you have to know what my religion is and what my spouse's religion is. And if the difference between those is what prompts me to be fired, then that is discrimination based on my religion. In the same way that you can say try to mask it in neutral terms and say it's discrimination against everyone in a same-sex relationship. But in order to apply that and have a problem when Pat marries Robert, you have to know that Pat is Patricia in accounting and not Patrick in accounts receivable. And for the individual to be discriminated against, you have to know what their religion is and what their sex is in my hypothetical, and so therefore the same rules should apply. And in that sense, I do want to touch on an argument that was offered, which by the other side, which I want to say, if there is one radical reinterpretation of Title VII that's being offered before this court today, it's not by me and the two gentlemen who preceded me to this microphone. The idea that, first off, discrimination against people in interracial relationships is, as they often say, often and almost always because of racist motives and ideology, and because someone deems one race to be inferior or superior. But please do not believe that that is a necessary condition to define discrimination against somebody in an interracial relationship, or this is the same way in my hypothetical, it's not necessary to find discrimination against somebody who's in an interfaith marriage. One is not exonerated, and we know this from Manhart, by equal application or benign motives, or even scientific fact underscoring the nature of the differential treatment. None of that matters. Title VII actually releases the court from that kind of inquiry. It condemns all don't. On any of the enumerated traits the same way, and you don't.
I think we just heard an argument that doesn't condemn all discrimination; it condemns non-trivial discrimination.
And I join most of what my EEOC colleague said there. And although this court has been a little bit cryptic in why it in Longo and back in the 70s, and then again in the Tavora case in the 90s, exactly what rationale it was using to find that the hair length was acceptable. What has happened in many of the other circuits is especially in hair length cases, they go, well, Phillips versus Martin Marietta clearly says you can't have one policy for men and one policy for women. So saying you can't have shoulder-length hair if you're a man, but you can if you're a woman, would seem problematic. And the way they got around that was to come up with various tests. I will say the Supreme Court has never signed on to any of these differential treatment rationales, but this court doesn't have to do any more work than it needs to in overturning Simonton and Dawson by overturning Longo and Tavora if it doesn't want to, because it can rest on the rationale that my colleague mentioned, which is that all that's being asked in that case is what the court deems something fairly trivial, whereas asking a man to give up his relationship with a man or a marriage to a man is now something that we didn't know 20 years ago, where the courts hadn't recognized was an actual constitutional right. Now we do.
Don't those cases, again, draw into question whether the but-for test can be the best construction of the language in the statute, or we have to say those cases are wrongly decided, or there's exceptions, but they're not covered by the manner test.
This court may very well need to should probably revisit Tavora and Longo. It's actually pretty glaring that Tavora doesn't mention Price Waterhouse, even though it was decided 6 years after Price Waterhouse. But if you're asking me, do we have to overrule those? I agree with Your Honor 100% that there is a differential between what the Supreme Court has said and what the circuit courts have said as far as tolerating gender-based differentials. But if you don't want to do any more work than you have to in overruling Simonton and Dawson, it would be sufficient just to rest it on that the differential there did not involve a constitutional right, and the differential here with Mr. Zarda absolutely does.
But there's no prohibition on discriminating against people for exercising their constitutional rights, right? A private employer can, as we've read a lot in the newspapers the last couple of days, can fire someone for expressing his political opinions.
Absolutely, Your Honor. We certainly have, and it would be only because of the differential in sex. It's not just gay men and lesbians who have a fundamental right to marry. It's everyone has a fundamental right to marry, and so and it would only be problematic.
An employer could, as with Judge Jacobs' question, prohibit non-marital sexual relationships among employees or marriages. And said we want all single employees or something like that.
And whatever problems would be with that, I don't think they would fall under Title VII, Your Honor.
Just to be sure I understand where you would take us on this, if we had an employer whose entire workforce was male, and he undoubtedly fired a male because he was homosexual, no question about it, and replaced him with a heterosexual male, do we have an employer engaged in sex discrimination?
We do, Your Honor, and I think that tracks the on-call fact pattern very nicely. Another problem with the Department of Justice...
Why? Because
yes.
Usually we think of these as advantaging men over women or vice versa, or disadvantaging one sex over another, but not disadvantaging within sex unless it's to benefit the other sex. So I'm not sure how it would work in that hypothetical I gave you.
Yes, and just understanding that the offshore Sundowner Offshore Services was an all-male work environment, and Joseph On-Call, we don't know exactly why he was singled out for the sexual harassment that none of the other men, and it was only men on that trawler, who were, we don't know why. Was it because he was cuter? Was it because he was more available? Was it because he was weaker? Because he was actually gay himself, and therefore we don't know what that was, but it didn't matter. His being male made him attractive to his supervisor, and that's all that mattered, and therefore sex discrimination occurred.
It was a harassment case, right?
It absolutely was, Your Honor, but it's differential treatment because it was something, and it also, Manhart's very careful. It doesn't say treatment of one sex that would be better if you were other sex. It says different, and that's important. The DOJ brief says the treatment must be worse. That's not what Manhart says, and that's not what the law is.
Thank you.
Thank you. I appreciate the privilege of addressing the court.
Mr. Zabel?
Your Honors, may it please the Court, I feel like we're here on false pretense. The facts to the extent that they've been argued here today, and it's only been a very small part of the argument, don't resemble what's being argued. Donald Zarda was...
That the question before us is a pure question of law.
I understand that, but if you decide this pure question of law without taking into account the facts, then you're doing the law a disservice, and we're exceeding the judicial mandate.
Well, let me ask you along those lines. You argue that Mr. Zarda didn't raise his current claim to the EEOC. Right?
I quote, "I am not being underlined, making this charge on the grounds that I was discriminated on the grounds of my sexual orientation." That's Special Appendix 3, Paragraph 2. That's his sworn affidavit to the EEOC.
How was he going to do that at the time, though? Baldwin hadn't been issued, and the EEOC had taken a contrary position. A week after Baldwin is issued, he files a motion for reconsideration before the district court to reconsider the summary judgment on exactly that basis. How could he have done anything else to tee up that issue?
Same way they did it in Hively. She came right out and said, "I am making this claim because I was discriminated against because of my sexual orientation." If they want to assert the claim and if they want to change the law, they have to plead facts that support that.
How about his EEOC charge, right? His EEOC charge, he says, and I quote, "In addition to being discriminated against because of sexual orientation, is also discriminated against because of gender."
Right.
Right?
Was that, I'm sorry, I didn't want to speak.
Yeah.
Okay, so...
I mean, isn't that precisely, and then he goes on to say he was fired because, I quote, "The levity he used honestly referred to his sexual orientation and did not conform to the straight male macho stereotype." Isn't that the kind of claim that Zarda is urging us to say is included within Title VII?
If you look at his EEOC charge as his ticket to file a complaint in federal court, and you look at his federal complaints, 1, 2, 3 complaints failed to allege discrimination based upon sexual orientation under Title VII. They allege it under the state human rights law, but not under Title VII. They just go with the sexual stereotypes, which were addressed by Judge Bianco and dismissed, as was brought up earlier.
Did you raise this before the district court or the panel here?
I'm sorry.
Did you raise this argument before the district court in the reconsideration motion or before the panel in this court?
It was raised before the district court in the reconsideration.
You said he didn't exhaust this, Your Honor. I didn't find that in the district court's record.
But that was absolutely argued before the district court.
You say that he didn't raise a sexual orientation claim in the complaint before the district court, correct?
The sexual orientation claim that he raised is the sex role stereotype complaints that were raised before the district court, which Judge Bianco addressed, and which the first panel acknowledged.
Your memorandum of law, right, in support of your motion for summary judgment, and I'm quoting, says, one of the plaintiff's theories is that he was terminated because of his sexual orientation. And you responded, didn't you, by arguing that plaintiff cannot advance a Title VII argument for sexual orientation because of this court's decision in Simonton. So aren't you conceding that these claims were, in fact, properly before the court?
I am not conceding that. They're alternate arguments. So if he does not raise the issue of being discriminated against because of his sexual orientation in his EEOC charge, then he doesn't get the opportunity now, 7 years after filing the EEOC charge, after all the facts are out in this case, to now somehow amend his pleadings and amend his EEOC charge to say, oh, no, 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 because the court might be willing to change its interpretation of the application of Title VII to sexual orientation, I want to now change my EEOC charge to make it fit what the court might consider. That is exactly what he alleged at the EEOC. I was waiting for this court to say to me, why shouldn't we rule like Hively? And my response is, because in Hively, they actually allege discrimination based upon sexual orientation. So here, when we have the only claims that we need to investigate from an EEOC charge and then brought forward to his federal complaint, we looked at the allegations. Those allegations were investigated by the EEOC. We were put on fair notice, and they were decided by Judge Bianco.
Could you just point to where you argue the exhaustion point before here? Where did you make the exhaustion argument?
That I did not. Other than arguing in the reconsideration that it was not raised, that was the only place it was argued.
Counsel, the plaintiffs argue that you waived the waiver by not raising it any time before today.
Yeah, and jurisdiction is not waived, and that's part of our argument. If the plaintiff has no right to be before this court because there is no jurisdiction, or he's asking this court to make a decision that's going to send this case back to Judge Bianco to decide a sexual orientation case that wasn't pled under the EEOC, then he's sending this court on a fool's errand.
The district court granted summary judgment relying on Simonton, right?
In part.
Well, but in part, but that issue is before us now because the district court made a ruling based on Simonton.
And the district court also made a ruling that all of the allegations, and now I'm taking from the decision of the first panel, all of the allegations regarding sex role stereotype were analyzed by Judge Bianco and denied, separate and independent.
The question of whether discrimination based on sexual orientation violates Title VII was ruled on by the district court, correct?
Yes.
All right, so why isn't that issue before us now?
It's not, it shouldn't be before, it obviously is here before you. It shouldn't be because if you look at his EEOC charge, he specifically disavows that this is a claim about his sexual orientation.
So I'm still confused about the EEOC charge. The way I have it here as from the Special Appendix 3, he does start by saying, I am not making this charge on the grounds that I was discriminated against on the grounds of my sexual orientation. Rather, I'm making this charge because, in addition to being discriminated against because of my sexual orientation, I was also discriminated against because of my gender. That's poorly written. The second sentence seems to contradict the first, but it clearly raises the issue of sexual orientation. Why am I wrong in reading it that way?
Reading it in that vacuum, it does contradict it, but reading it where he's also asserting a claim of sexual orientation under the state human rights law where it's permissible, it makes sense. You can read it. I am not claiming sexual orientation discrimination under Title VII because when you look at the next paragraph, paragraph 3, he talks about specifically what he's alleging. And that specifically what he was alleging is mirrored in complaints 1, 2, and 3 of his federal lawsuit, and that's what was analyzed by Judge Bianco.
He goes on to say, my claim is that because I did not conform my appearance and behavior to sex stereotypes, I suffered adverse employment action. That's what the legal question before us is.
No, I'm sorry.
Go ahead.
It's not my place to say no. But it is Judge Bianco's determination that his sexual stereotype claims failed because there was no way a jury could conclude that what he specifically alleged could support a claim for his termination for sexual orientation. And that part...
Yet the judge let it go forward under the New York labor law.
Yes.
Correct? Under a different standard of proof of causation, potentially, right?
Yes and no. Yes, the judge let it go, but in the judge's decision, he said the facts that were alleged, when coupled with testimony that could come out at trial, could support a claim. The problem is now we have a closed record. The facts that came out of court came out. We had people come in and testify. And it wasn't what the plaintiff said. The young lady who was jumping with him said, hey, he made the joke about being strapped to me, and he only disclosed to me his sexual orientation when he felt that I was uncomfortable because he was hitting on me. So if anything, he was terminated for heterosexual activity, and he tried to cover that by saying to her, don't worry about me. I'm gay. I just broke up with my boyfriend. Oh, by the way, I'm falling from the sky strapped to this guy while he's saying it. So whereas counsel will say, well, he said to her, he's gay, that's out of context. It's, don't feel uncomfortable that I'm nuzzling you and trying to speak to you in an affectionate way, which is what she testified.
Speaking of nuzzling, that sort of reminds me of horses, which I live with on occasion. why isn't this cart way before the horse? We're here trying to decide whether what's alleged in the complaint fits within Title VII. We're not at the point where we're able to analyze the facts of the case, unless for some reason you've made an Iqbal or Twombly argument, which I don't see.
No, I didn't make an Iqbal and Twombly argument.
But you're sort of arguing today the facts are there and they don't support the claim.
Because those facts have already been before a jury, and a jury has already concluded under the state standard that he was not discriminated against based upon sexual orientation. And to the extent that we look at Judge Katzmann's decision, his concurrence in Christensen, it seems to be moving to a but-for standard as to whether or not sexual orientation discrimination occurred. And if that's the case, if we take that but-for standard, then you have to decide that the jury verdict under the state law, which was a but-for standard, also has to apply here. Again, you're being sent on a fool's errand on facts that don't reflect what came out at trial.
The standards are different. The federal standard is a motivating factor, not the but-for standard under which your client prevailed.
I understand that, but when I read Judge Katzmann's concurrence,
I'm not sure you're reading it as fully as one might.
When I read this, and I hear everybody argue, part of the argument is, yeah, you look for it and you make a but-for decision. And if you're taking that but-for decision, you cannot divorce that from the verdict that we already have. I see I'm out of time unless there are other questions.
Thank you.
Thank you.
Thank you.
And thank you for the honor.
In light of the judicial consensus that existed for over 50 years that Title VII's prohibition on sex discrimination does not reach sexual orientation discrimination, there are 3 reasons why Congress has ratified that position.
Well, can I interrupt and ask a question about why you're here? Does DOJ ordinarily defer to the EEOC on Title VII questions?
No, Your Honor. The EEOC has control over private party litigation, but DOJ has primary control over public litigation, and DOJ is, of course, also the nation's largest employer.
These
so,
private parties, I don't understand the distinction.
Well, the statute would, of course, apply equally, whether it's a private party or a public party. So the government has an interest both in its regulatory capacity on the public sector side.
Who was the representative from the Civil Rights Division on this brief? Is it Mr. Wheeler?
Yes, he was the acting head of the Civil Rights Division at the time the brief was filed.
So in Hively, the EEOC filed an amicus brief, but DOJ did not. Is there some reason why one wasn't filed then, but one is filed now?
I'm not sure, Your Honor.
Has there been any discussion about that?
I'm sorry?
In November of 2016, that might have something to do with
I suspect it might, Your Honor.
I thought that might be your answer. Is that the reason?
Well, it's before my time at the department, Your Honor, so I honestly couldn't tell you.
We can take notice of that.
What is the process within the government where you've got, and I know it varies with respect to which agencies you're talking about, whether they have independent litigation authority. With respect to the EEOC and the Department of Justice, what is the process that is entered into in terms of filing a brief?
I'm not exactly sure what you're getting at, Your Honor, but I also am nervous.
Well, in other words,
can
the EEOC file its own brief without consultation with the Department of Justice? This goes back to Judge Pooler's question.
That's a fairly complicated question, Your Honor, and I would
try to help us.
Yeah, we can understand.
What I will say is this: the EEOC had the authority to file the brief that they have filed in this case, and the Department of Justice, of course, has the authority to file the brief that is filed in this case on behalf of the United States.
Do you know if the Employment Litigation section of the Civil Rights Division was consulted in connection with filing this brief?
Your Honor, I don't think it's appropriate for me to disclose the deliberative process within the department as to it. I will note that, as the questions noted, the acting head of the Civil Rights Division was on that brief, as well as the acting head of the Civil Division.
Are we entitled?
As part of this complicated process, does DOJ sign off on a brief that EEOC intends to file?
Again, I don't think it's appropriate for me to speak to internal deliberations and internal processes.
Just ask if it's the procedure, not internal deliberations.
Your Honor, I don't think it's appropriate for me to comment as to whether we signed off on the briefs that they filed.
Not just brief.
Or in general.
Ordinarily, would DOJ sign off on a brief filed by an agency of government?
Your Honor, I'm sorry, but
Doesn't the EEOC, like the SEC, have its own litigation authority? I mean, there are cases brought in the name of the EEOC and in this court, the courts of this circuit, and every place else in the country without DOJ approval, right?
Your Honor, we are not disputing that the EEOC had the authority to file the brief that they filed here, and beyond that, I just don't think it's appropriate for me to comment on the degree to which the department was involved with that.
I, for one, am prepared to proceed on the assumption that you're here.
Thank you, Your Honor. So,
let me ask you this, since you are here. Why can't the associational analysis be performed, notwithstanding a stable meaning of the word sex for the last 50 years as denoting men and women? In short, if just on the analysis with race.
So there's a fundamental.
You have men and you have women, but a person of a certain race cohabiting with a person of another race is discriminated against.
So there's a fundamental difference, Your Honor, between race and sex when it comes to associational discrimination. If you say that someone discriminates on the basis of interracial marriage, everyone would call that person a racist. But if you say that you discriminate on the basis of sexual orientation, you might call that person a lot of things, but the one thing you would not call them if you speak English is that they are a sexist.
Well, you might call you might call them a homophobe, if I understand what that word means.
You might do that, but you would not call them a sexist. And the reason you would not call them a sexist, even though you would call the person who discriminates against interracial marriages a racist, is because when you discriminate against interracial marriages, you're treating similarly situated black and white people differently, and you are doing so based on views about racial superiority. When you discriminate on the basis of sexual orientation...
Why do you need racial superiority? I mean, the same thing would apply to people of two races, even if one of the races is not white and one of the races is not black.
Even in that circumstance, Your Honor, you're still treating individual of two different minority groups differently who are otherwise similarly situated, and that's simply not true when you're dealing with a man and woman and in the context of sexual relationships. And these arguments are not new. The associational argument, for example, was made...
Can you point me to some cases that make this proposition, support this proposition?
Well, so I was about to say, so the associational argument was made in the Ninth Circuit in DeSantis in 1979, and it was rejected. And there were several other circuits that rejected, in general, the argument that sexual orientation was subsumed within sex discrimination. And then in 1991, Congress engaged in a comprehensive amendment to the Civil Rights Act, and it overturned several other areas where it disagreed with the judiciary, and it did not overturn these cases. And under cases like...
When you say disagree with the judiciary, one of my colleagues pointed out before, would that include circuit court decisions or only Supreme Court decisions?
So in the 91 amendment, it was Supreme Court decisions, but importantly, the Supreme Court has found ratification in circumstances where Congress has rejected lower court decisions. I would point the court to Lorillard versus Pons, which we cite in our brief. In Lorillard versus Pons, the Supreme Court did two things on the ratification front that are critical here, and both of which reject expressly the arguments made by the EEOC here today.
Wouldn't it be, I understand your argument, but wouldn't you have a more powerful argument if sexual orientation discrimination cases were cases that in 1991, in the context of that specific act, Congress specifically dealt with? Congress knew how to deal with specific acts. It did so in the 1991 decision, specific court decisions, but it didn't do so with sexual orientation discrimination. Why are you saying that we can make that leap to say, even though they didn't talk about it, they really did, which is what you're saying?
Right. So I have 3 points about that, Your Honor. The first is that's exactly what the Supreme Court did in Lorillard versus Pons, where the question in the case was whether the ADA had a jury trial right. And what the Supreme Court said was that the Congress was trying to incorporate the FLSA, and in the FLSA context, lower courts, not the Supreme Court, lower courts, and only a handful of lower courts, one circuit court and a couple of district courts, had found there was a jury trial right. The Supreme Court found ratification based on that. Moreover, and directly responsive to your question—
That's not, I mean—
if I could just finish, because—
I'll let you finish and then I'll ask you a question.
Right.
Thank you.
To further their point, they said Congress in the ADA overturned other aspects of FLSA jurisprudence. And what did they point to? Lower court opinions on the scope of the FLSA rights. Not the question of the jury trial right, other contexts. And they said because Congress overturned other parts of the FLSA, we will assume that they ratified the parts that they didn't touch. That is also exactly what the Supreme Court did in the Farragher decision, which we also cite in our briefs. In Farragher, what the Supreme Court said was the 91 Civil Rights Amendment, the very law that's at issue here. The Supreme Court said that when Congress overturned a variety of other Supreme Court decisions in other areas, but didn't touch Meritor, which was about the scope of supervisory liability for employers, they ratified that. So you're right, Your Honor, it would be stronger if the 91 Congress in the Civil Rights Bill had specifically talked about sexual orientation, said, we like all those decisions. But the Supreme Court has never said that that's the test for ratification. What the Supreme Court has said is that if you have a comprehensive amendment to the statute, leave standing a judicial consensus on one issue, and overturn areas in another area, even when it's lower courts, that is a ratification. That said, I will also know that the 91 Congress did address sexual orientation specifically, because in 1991, just like in every Congress going back to 1974 today, there was a bill put forward to Congress to actually add sexual orientation. And the bill sponsor said that that was necessary because federal law did not cover it. And despite that, Congress did not enact that bill and has never enacted that bill. And that's what fundamentally is different from the PBGC opinion that the EEOC relies on. In PBGC, the situation was that the PBGC had taken a certain position. There was a bill in front of Congress to ratify it. They didn't end up passing the bill. And what the Supreme Court says is we don't know if they didn't pass that bill because they already agreed with the PBGC or whether they disagreed. That's totally distinguishable from a context like this, where every circuit court for 50 years has said that this is not covered. Every year from 1974, Congress has had a bill before it to overturn that, and every time they don't do it.
Can I go back to the associational argument for a minute? I'm sympathetic to your point that miscegenation laws are a fundamental aspect of white supremacy. And that's not, we can't say that about this, that that bigotry against homosexuals is somehow about hostility to men or hostility to women as such. But what about in the case of religion? If you had an employer who was an Orthodox Jew, who had a workforce of mixed religion people, but then one of his Jewish employees married a Christian, and he fired that person, isn't that an example of religious discrimination that doesn't have to do with the special role of miscegenation laws or some aspect of racial superiority or something like that?
Well, I'm not sure if in that hypo it wouldn't be based on religious superiority, but even setting that aside, the more fundamental point, Your Honor, is that in that circumstance you're treating similarly situated Jews and Christians.
No, the Christian can marry another Christian, and the Christian can marry a Muslim or a Jew. He doesn't care about that. He doesn't want to see Jews marrying non-Jews.
Right. So the Jewish person is being treated differently than otherwise similarly situated non-Jewish people.
Yeah.
Right. And so that is why that is.
Why is that not the same? That's right. The argument that Mr. Nevins has made.
That is the argument, and the difference is, unlike Jews and non-Jews, who there are no factual differences, and the law does not recognize differences between Jews and non-Jews. There are real differences between men and women, and the law recognizes real differences between men and women. And this is vividly vividly illustrated by the situation of the bathrooms, where everyone recognizes that Title VII does not prohibit having single-sex bathrooms. Now, the EEOC comes here today and says the reason why that's okay is because it's trivial. And that is, frankly, an astonishing proposition for the EEOC to take. Because if the argument is that terms and bathrooms are not a term and condition that matters for the discrimination statutes, then you could have black bathrooms and white bathrooms. It's the same exact term and condition. They have no argument for why, if it's because of term and conditions, you couldn't have segregated, racially segregated bathrooms today. That is obviously wrong. And what it demonstrates
is...
is...
sex discrimination is sort of okay because there are real distinctions between men and women, but racial discrimination and religious discrimination are not?
That is absolutely the case, and that is what the Supreme Court...
Sex discrimination is prohibited by Title VII, I thought, last time I looked at it.
That is absolutely true, but the critical difference, Your Honor, is that discrimination requires treating people who are similarly situated differently. And unlike with race, where black people and white people are similarly situated in all relevant respects under both law and fact, men and women are not similarly situated in all respects. The law recognizes that there are real physical differences between men and women.
Which has something to do with this marriage issue?
Yes, Your Honor. The same exact physiological differences that are relevant to bathrooms are the same exact physiological differences that an employer is allowed to take account of when they're regulating their employees based on their off-the-work sexual relationships. And there were several questions about this, and the EEOC agrees that employers under Title VII are allowed to do that. Employers under Title VII are allowed to regulate their employees off-the-job sexual behavior. They're allowed to say if you cheat on your spouse, you're fired. They're allowed to say if you're promiscuous, you're fired. None of that is covered by Title VII because Title VII only covers race and sex and religion and the other protected traits.
Do you agree that ethnicity is covered by Title VII?
I'm sorry, is what?
Do you agree that ethnicity is covered by Title VII?
Yes, I think ethnicity can be viewed as a subset of race.
And why is that?
I just think as a matter of ordinary English, you can parse race and ethnicity.
Judge Flom went through when he said, as a matter of ordinary English, I look at the dictionary and homosexuality is a subset. You can't distinguish that from sex.
Look,
why isn't that the same analysis that you would apply, that you just applied in the context of ethnicity, which we found, and you agree, is covered by Title VII, but the word ethnicity is not in Title VII.
I'm not disputing as a logical matter, Your Honor, you could view sexual orientation as a subset of sex, but you could also, as a logical matter, view it as a distinct category. And the question is whether under this statute that was passed by Congress, which one of those two it is. And we know very well which one it is because several times Congress has actually prohibited sexual orientation discrimination. It has done so saying, in addition...
It's not in a contemporary, when laws are passed in a contemporaneous Congress, then they have a different impact than when laws are passed separately from contemporaneous enactments. Would you agree?
I think that's right, Your Honor, but in this context it gets it exactly backwards. Think about what would happen today if Congress were to pass a statute that says no sex discrimination. It would be indisputable, I submit, that didn't cover sexual orientation discrimination.
That did or didn't?
That did not. That covered sex. If it just said sex discrimination, I think it would be indisputable that did not cover also sexual orientation discrimination. The reason being you would have both until this year, unbroken set of case law saying the two were distinct, and you would have several prior acts of Congress that treated them as distinct. So if that's the case today, then surely a fortiori in 1964, when Congress passed the same exact word, they didn't have some broader notion of sex discrimination compared to what we would have today. It just makes no sense, Your Honor.
What about Uncall's suggestion that sometimes the statute can be read to prohibit a comparable evil?
I don't dispute the proposition, Your Honor.
That's a statement.
That's absolutely true, Your Honor, but it's not applicable here. The point in Uncall was the statute covers sexual harassment under meritorious and under plain English. And the only question is whether does that prohibition encompass same-sex harassment. And the point was, by its plain text, it clearly does. And the fact that Congress wasn't thinking about...
Excuse me. You said by the plain text it covers sexual harassment, but that's not written in the statute. It just says discrimination because of sex, and it took quite a series of cases to construe that to include sexual harassment. Or am I misremembering?
I'm not sure about exactly how long it took, but it seems to me that when you have a statute that says you can't discriminate based on the terms and conditions of sex, that fairly readily supports the proposition that it covers sexual harassment.
I would refer you to a D.C. Circuit opinion, Barnes and Costal from the 70s, that went through quite an extensive review of the history of the Civil Rights Act, and that labored over this because the initial inclusion of women at all was subject to question. So I would suggest to you that the statute has grown more in line with Justice Scalia's description and that Judge Katzmann just referred to than you're acknowledging.
So let me qualify what I said. Even if you think there was a debate as to how clear it was that sexual harassment period was covered, once Meritor held that it was covered, there is no dispute that there's any difference based on whether it's a same-sex or opposite-sex harassment. There's nothing in the language of the statute that can get you there. And so that was Justice Scalia's point in Oncology, that Congress might not have been thinking about that fact pattern, but it's covered by the text. But in this context, on the other hand, sex discrimination and sexual orientation discrimination have always been understood, not just in terms of the subjective intent of Congress, but in terms of ordinary English, as confirmed by the fact that every court for 50 years held this. The EEOC held it for 50 years. And the EEOC, by the way, they suggest...
You keep mentioning the 50 years, but the landscape changes in terms of the law, right?
Well,
marriage is different now?
I'll do 20 years, Your Honor, after Price Waterhouse, after Oncology.
Why can't the same be said about sexual orientation?
Well,
the landscape has changed.
Because even after Price Waterhouse and even after Oncology's in 1996, every court in the country for another 20 years said that, including the EEOC. The EEOC had cases explaining that Oncology didn't change their position, and I would urge this court to read them. Those EEOC opinions are not any differently reasoned than the court opinions that from 1979 that we cited to, that we say Congress ratified. There is a fairly common sense, intuitive difference between sex discrimination and sexual orientation discrimination.
I thought you just said that you could see as a logical matter that sexual orientation could be a subset of sex.
Right, as a logical matter, there's a difference between whether you can, as a theoretical matter, come up with a hypothetical but-for construct.
Is it the government's position that the plain text of the statute clearly excludes sexual orientation?
I think it is clearly the better reading, and so yes, but I think that this court doesn't need to get into whether it's ambiguous or not, because any ambiguity is resolved.
Can you point me to what language in the applicable provision of Title VII clearly excludes sexual orientation?
Just the ordinary definition of what discriminate on the basis of sex means. It means treating similarly situated men and women differently, and that is not happening here any differently than it is for bathrooms. Well, so I guess I will say this, it is no less ambiguous than whether Title VII bans single-sex bathrooms. And since I don't think anyone thinks it does, and I don't think any court has ever held it and ever will hold it, and their only argument for why it's different is an argument that would blow a massive hole in the statute by saying that terms and conditions don't cover bathrooms, such that we could have colored bathrooms again. I think it is clearly the better interpretation. But even if you don't think it's unambiguous, it is certainly at least a strong enough interpretation that the fact that Congress has ratified it repeatedly in various ways should count. If I can make one last point on ratification, Your Honor, which is, as I said before, they point to the PBGC opinion.
I'm having trouble with your term ratification. Yeah. When I hear the word ratification, I understand that to mean an explicit statement, as they have done, Congress has done in many, many cases. Where is the explicit ratification?
That's not the way I'm using the term ratification. It's not the way the Supreme Court has used the term ratification in cases like inclusive communities and Lorillard versus Pons, the way I'm using the term, and I'm not wedded to the term, but it's the principle that I'm focusing on, is that when there is a judicial consensus on an issue and Congress amends the statute and leaves that consensus undisturbed, that is a ratification of that position. That is what the court held in Lorillard, and that is what the court held in inclusive communities.
Is there a difference in the inclusive communities? Didn't you have 9 courts ruling?
Right.
And in the cases that you're mentioning with respect to the 1991 Act, the Congressional Act, you have 3 courts that had acted in that area at that time.
No, well, 2 points. First of all, I think technically it's 4 and arguably 5, which we cite in our brief, but more importantly, Lorillard had less than that. Lorillard versus Pons found ratification, citing 1 Fifth Circuit opinion and 1 district court opinion, and 2 law review articles that cited a handful of other district court opinions, and they found ratification. So 4 is a whole lot more than 1, Your Honor. But I did want to make one other point about congressional acquiescence, which is technically a different argument than ratification. Ratification, as we just discussed, is when Congress actually amends the statute and leaves undisturbed. Congressional acquiescence is the point that since 1991, year in and year out, Congress has been presented with a bill to undo this consensus, and it has not acted. Unlike the PBGC case, I would point this court to the Klein decision, which we cited in our brief, where again, the court found, based on 2 circuit courts and a handful of district courts, that the fact that the Congress hadn't disturbed that was strong evidence that that was the correct interpretation of the statute. Here we have every federal circuit court, the EEOC, for over 20 years, in the face of Price Waterhouse, in the face of Oncology, and then you have Congress passing statutes using the term sexual orientation specifically and separately, and moreover, doing it by saying sex or sexual orientation, not saying, as their argument would suggest, sex including sexual orientation, which is what they did in the Pregnancy Discrimination Act in 1978. When Congress overturned Gilbert in 1978, yes, when Congress overturned the Gilbert in the Pregnancy Discrimination Act of 1978, they said sex including pregnancy, which showed that they thought that pregnancy was subsumed within sex.
Thank you.
Thank you.
Thank you for your argument.
May it please the court, Adam Mortara.
I'd like to say at the outset that the court appreciates Mr. Mortara accepting the court's invitation to brief the argument that he's about to make.
Thank you, Your Honor. The but-for test, however it is applied, does not categorically define sex discrimination, and we've had ample discussion of why that's true today, particularly with regard to sex-segregated bathrooms, but also the Bauer case from the Fourth Circuit, with the FBI literally having different numerical standards for numbers of push-ups between men and women, and a man for whom it was apparently, Mr. Bauer, his life's dream to become a special agent of the FBI, missed the push-up count by a few, and if he had been a woman, he absolutely would have been made a special agent. It was not disputed, and yet that was not sex discrimination. The but-for test, as applied by, I guess, the appellants here, but maybe also sometimes by the way the government would put it, gives you false positives. And so it cannot and does not define what is sex discrimination. And I don't really have much of a strong position about how the but-for test should be applied here, largely because it's not an interpretive device. It's not a device for interpreting Title VII. It is an evidentiary standard. It can provide clues as to whether the real reason was sex discrimination, but it doesn't provide the answer. And a few other examples, you know, we talked about trivial in terms and conditions. I agree with my friend from the Justice Department. Bathrooms are not trivial. OSHA requires sex-segregated bathrooms, actually requires in a multi-toilet situation that bathrooms be sex-segregated.
You've told us that it's not but for, it doesn't apply here. Would you have a term to use instead that would be more accurate and more helpful?
I think I'd start at the top, which is the true reason has to be discriminatory. The true reason has to be because you are a man. So that's the top. And I think to sort of fill that out and get to that answer, I'd say the but-for test is helpful. And then I'd say there has to be an unequal burden applied from one sex to the other. That's what the Ninth Circuit does in their dress code line of cases, which starts out with United and Continental Airlines having different weight requirements for flight attendants, or I think one had a requirement that flight attendants actually be unmarried. And those were determined to impose an unequal burden on the sexes, but then ends up in Jesperson, where women have to wear makeup and men are not allowed to wear makeup, and women can color their nails and men cannot. And while the but-for test fails there, it was not an unequal burden, and same with the FBI in the Bauer case.
You say, as I understand it, that a truthful response about why an employer fired a gay man would be because he was gay, not because he was a man. But isn't that arguably an incomplete answer? And that saying someone is gay is a shorthand for saying that the person is attracted to other men. So that that is the real reason. If you pursue it more. So in the Price Waterhouse case, for example, if Price Waterhouse had argued that they discriminated against Ann Hopkins not because she refused to wear makeup, but because she was a gender non-conforming person, would that have been a defense?
No. And the reason, it strongly depends on the facts of Price Waterhouse and the catch-22 that was alluded to earlier. You see, the problem in Price Waterhouse is the catch-22. She was aggressive, but then you had to be aggressive to get the promotion. The Price Waterhouse would have fired a docile or passive man, presumably under the catch-22 and the facts that were given. But no, it is not true that merely being non-conforming to gender by itself gives you a sex discrimination claim. It has to also be true that there's something additional, evidence of misogyny, evidence of highly traditional, for instance, sexist views about women and children. That's kind of the back case from this court. There has to be something more. It is not true that sex stereotyping standing alone can give rise to a sex discrimination charge, or Ms. Jesperson would still have had her job at Harrah's Casino. And by the way, going back to the trivial point, the issue of wearing makeup was so important to her, she quit her job that she'd had for a very long time because of it. So I really do not understand that the talking about dress codes and talking about bathrooms as if they're nothing to people. They can be extremely important, as they were to Ms. Jesperson.
Why is it that you seem to posit that Title VII was directed at animus as opposed to something else? I mean, there are these adverse impact cases that are under Title VII that have nothing to do with animus.
And that's a different provision of the statute. And Your Honor, if you've interpreted me to say Title VII is only about animus, then I should clarify. It's not only about animus. The disparate treatment section of Title VII is not only about animus, but it is about what motivated the decision. And animus is the smoking gun evidence that the subject category motivated the decision.
But you're asking us, I thought, but maybe I misunderstood, to view animus as some helpful interpretive tool. No.
It's not. I think animus is not just a helpful interpretive tool. Animus is sort of the res ipsa loquitur of the whole thing. If you find animus against a subject category group, end of story, it's disparate treatment. But that does call to mind some of the hypotheticals about interfaith marriages and interracial relationships I'd just like to briefly address. On the interfaith hypothetical, it was posited about the Jewish employer marrying out of the faith. That absolutely would be discrimination on the basis of religion, almost without question, as the hypothetical was stated, because the Jewish employer, the employer, he doesn't need to be Jewish, would have an idea, a notion of how Jewish persons were supposed to behave, and he would have imposed that notion on the Jewish employee, and the truthful answer in the Price Waterhouse question would have been, I fired you because you are a Jew, and Jews are not supposed to do that. And that, so that
What's the difference?
I don't see why you couldn't say exactly the same words that you just said, substituting man for Jew.
The words could be used, but there actually is no word for somebody who is, for instance, just opposed to interracial relationships. And the word that we use to say somebody is opposed to gay relationships is home.
What, when you say there is no word for someone who's opposed to an interracial relationship,
you just made exactly my point.
That's a racist.
You just made exactly my point. On the interracial discrimination cases, well, all that is a statement that there is no studied neutral opposition to interracial relationships. It does not exist. It's res ipsa loquitur. When somebody says, I oppose interracial relationships, they are effectively saying, in this country, I am a white supremacist. And there's just no room. Whereas somebody who says, I oppose intersex relations, or homosexual relationships, rather, there's a name for that person. It can be.
Are you really positing that it is implausible that the members of every race may view with dismay or disgust someone like themselves marrying someone who is not?
I'm not positing that that's impossible. I'm saying it's racist.
It's impossible. You're assuming that it is only white people, based on an idea of white supremacy, who would object to someone, a white person marrying someone of another race. And I think it's just as plausible, I don't know why it wouldn't be, that a member of that other race would view the same marriage or a liaison with dismay.
That's exactly right. What I mean by there's no studied neutral opposition to interracial relationships is there's one that's not race neutral. In other words, you're positing a situation where, say, an Asian person objects to, a Chinese person objects to a Chinese person marrying out a non-Chinese person. That would be exactly the same as the Jewish-Christian marriage hypothetical. It would be a Chinese person with an idea about how Chinese people should behave, firing somebody because they are Chinese. In this,
Judge Lynch's question.
Yeah,
you're saying that the animus is not against whatever sex it is that the person is marrying. The animus in the bias against gays case is specifically against gays. It doesn't have anything to do with hostility to men.
That's correct.
Someone who is bigoted against a man who is other men has nothing against men. Someone who is opposed to someone of his race marrying someone of another race does have something against the other race. Is that the point? Putting aside studied neutrality, which sounds creepy.
That's very close to what I'm saying. I don't like the associational line of cases for a lot of reasons, and I think it's much more about racial stereotyping of the race of the employee. So in the instance of a white marrying a black person, it's about how whites should behave. I would take issue with that a little bit, and I would qualify what you said only in the following sense. It is perhaps more possible that a gay man could be fired because there were an issue with gay men as opposed to gay women. And the Justice Department and I both concede that would be sex discrimination. And that's where juries are going to have to get into the evidence, and juries are going to have to look at why the person was fired. So I would qualify it in that way.
How do we sidestep the associational piece, which you're not comfortable with? Because it seems to me we have that lurking out there, and it can be used as a guidepost.
Well, I would say it, and I'd give you a couple ways to sidestep it. Number one, a lot of the instances of the failures of the but-for test could be classed as associational discrimination as well. I prefer to go to the bathroom with other men, for example, and therefore I associate with other men in the toilet. And so if you discriminate against me or discriminate against me because I prefer to associate with other men, for instance, in the locker room, which is quite similar to the bathrooms, and we have had discussions in the last year and a half about locker room talk too, and maybe it's not all great, and much of it is not, but at the same time there's an associational element there as well. But also beyond that, what I would say is associational discrimination doesn't get you much more than the but-for test. And when the but-for test is known to have false positives in sex, it's really not adding much for us. On race, the but-for test is as perfect as a test could possibly be for reasons that my friend from the Justice Department really alluded to. And so the way I would discuss the associational discrimination cases is to make exactly that point, that there are differences between race and sex, and we need to look no further than, again, I bring back to the bathrooms. After the '64 Act was passed, everyone understood that race-segregated bathrooms had to go, and yet OSHA still to this day requires sex-segregated bathrooms, and no one has persuasively distinguished this case from the issue of sex-segregated bathrooms. And talking about arguments that courts did and didn't have, it doesn't appear that the Hively Court, the en banc Seventh Circuit, in any way had in their minds this issue of the but-for test and sex-segregated bathrooms. It doesn't appear to have been discussed. Whereas,
Let me just interrupt for 1 second. So I have not thought this all the way through, but, you know, Title VII really focuses on economic opportunity. Segregated bathrooms has very little to do with economic opportunity, but employment discrimination, firing an employee, making other adverse moves, does in every respect. And Mr. Zarda here lost his job because of the actions taken against him. So could you explain why that might not be an active, useful distinction?
To be clear, if you go to the OSHA regulations on bathrooms, they think bathrooms are very important. They have regulations about the numbers that you're going to have and all this kind of thing. But also, the hypothetical really is a man wants to use the women's toilet for whatever reason. That was the issue in Castle. A biological male who was a transgender woman wanted to use the women's toilet, and it was very important to them. And very presumably important to their economic opportunity, just like Ms. Jesperson and her desire not to wear makeup. And yet at the same time, that is not sex discrimination. So
why is using the bathroom important to an economic opportunity?
Because your comfort level with whether you can relieve yourself has a lot to do with whether you can perform your work functions during the day.
There's an adverse employment action there? I mean,
if you deprive somebody of the opportunity...
Follow up on Judge Carney's question, I don't understand actually how bathrooms are that critical as a matter of Title VII. They may be critical as a matter of OSHA or some other regulation or law, but not as a matter of Title VII.
Well, number one, I'd say that would be news to all the people who woke up that racially segregated toilets could not be used after the Civil Rights Act that we're talking about today, under this exact provision we're talking about today. But also, it's absolutely an adverse employment action when Ms. Castle was fired because she wanted to use the women's toilet. She was fired. So sex-segregated bathrooms exist, and it's a rule employees have to follow, just like dress codes. And to round out the associational discrimination point, just one more. I own a tennis club, say, and I have tennis pros. And I say to my tennis pros, you may only enter mixed doubles tennis tournaments. And one of them comes to me, and you don't even know the sex, and they say, I would like to enter a regular doubles tennis tournament. And the answer is no. The but-for test is satisfied. Now I tell you it's a man and he wants to play tennis with other men, but I tell him he can't. But if he was a woman, he could play tennis with other men, with men. The but-for test is satisfied. It's an associational discrimination case. I'm discriminating against him on the basis of who he wants to play tennis with. It's all the things in this case. And what I'm going to hear back is, well, that's trivial. There is no hierarchy of values in Title VII. The text doesn't support it. Thank you.
Thank you. Mr. Antolino, you'll have 3 minutes in rebuttal.
Thank you, Your Honor. I would agree with my friend from Chicago that there is no hierarchy in Title VII. All 5 of the protected categories are treated the same, and you see that in footnote 9 of Price Waterhouse. There is no difference, and I had hoped that we would get through this argument without an extended discussion on bathrooms, but I knew that it wouldn't happen.
My question to you at the beginning was about this bathroom example.
Well,
and you've just heard your adversaries use that, I think in a somewhat effective way, to say, well, you know, we wouldn't consider allowing a racial difference in terms of use of bathrooms. Can you answer their argument?
Well, what if men and women have different equipment, and there's different equipment in the men's room than there is in the women's room? It is a custom. It is such a small consideration that for bathrooms to swallow the entire question is really to focus on a matter that doesn't matter to economic opportunities, which is what Eeoc, which is what Title VII is about. With respect to the charge, I contend that when we came into this case, we wanted to bring this theory to the district court, and we wrote the charge as best we could to preserve both our state claim and our federal claim. And we believe we did it well, as best we could, as poorly written as it was. But when Baldwin came down, within weeks we asked to reopen the question, and our request was denied. I would also suggest that the EEOC, with respect to the legislative intent, I don't think that there has been an answer to the pension benefit v. LTV Corp decision, which holds that subsequent legislative history is a hazardous basis for inferring intent. And in that case, it cited an Earl Warren opinion from 1962, which itself cited cases from the 1940s. So we have not 50 years of cases that hold against us, but we have an unbroken line of 80 years of cases that hold that negative legislative history is not a basis to make a decision. The but-for question will be something that necessarily is going to depend on the context and the facts. We cannot guarantee that it will work in every context, but Ancale held that we see no basis in the statute to be unduly formal and say that it doesn't apply, that male-on-male harassment does not apply. And sexual harassment, as Your Honor has pointed out, was not an established theory until 1979 in a district court case. And for years, courts had held that, well, this is just sexual attraction between men and women, and this is not what Title VII was intended to protect. Eventually, courts began to get it right, and there's no question now. The court has to interpret the statute. Your Honor, you know how the sausage is made. You wrote a book on it. I got the title wrong in my brief, but I did read it. And
at least you read it.
And one thing that you pointed out is that agencies are generally the first, often the primary interpreters of statutes. And thus, that gives weight to the EEOC's interpretation, where the DOJ, in this case, does not govern exclusively employment discrimination. And I believe that's all I have to say, unless there are any further questions.
Thank you.
Thank you.
Thank you all for your preparation and good arguments. The court will reserve decision. The clerk will adjourn court.